Hello, good morning and welcome to Gough Square Live. My name's Cameron Crowe and today I'm joined by Sabrina Goodchild. Sabrina and I are both barristers at Gough Square Chambers, specialising in consumer and trading standards law. That specialism extends to both the criminal and civil jurisdictions and includes advising and acting for parties in applications for enforcement orders under the Enterprise Act 2002, which is the topic of our talk today. We have chosen this topic because Part 8 of the Enterprise Act, which provides the mechanism for applying for and obtaining enforcement orders, has been somewhat underused by enforcers to date. Trading standards officers and services are, in our experience, far more comfortable with disruption action and, if necessary, criminal enforcement than with the Enterprise Act and civil proceedings. However, criminal cases, whilst often effective and carrying a deterrent effect, can be costly and will inevitably be subject to at least some delay due to the backlog of cases within the criminal courts. They also, of course, are subject to strict rules of evidence, limitations on the use of hearsay, for instance, and a high standard of proof beyond reasonable doubt. By contrast, enforcement orders under the Enterprise Act can be attained relatively quickly, presented simply through investigators, can be based on hearsay evidence if necessary, with the standard of proof being the balance of probabilities. Given those factors, one might have thought that the Enterprise Act would have been used more. However, there are changes afoot that may well mean both applications for enforcement orders and the legal principles behind them becoming more common. That change is the enactment of the Digital Markets Competition and Consumer Bill, which, importantly, will introduce the power for both courts and the CMA to impose monetary penalties on traders that infringe relevant consumer protection legislation. We are obviously not going to be able to cover this topic in just a 20-minute talk. We will cover, in broad terms, what is an enforcement order? What do enforcers need to prove? Pitfalls and avoiding them in this process, forthcoming changes, and then finally, pros and cons. So, Sabrina, what is an enforcement order?
Well, in one word, it's an injunction. An enforcement order, which can be sought by specified enforcers, is obtained from the High Court or the County Court to stop businesses or individuals from infringing consumer laws and to seek redress or compliance. The terms of such an order usually require the trader to do or not to do one or more of the following. So first, not to continue or repeat the infringing conduct. Second, not to engage in such conduct in the course of its or any other business. Third, not to consent or connive with a body corporate engaging in such conduct. And then fourth, to take enhanced consumer measures within a specified period. Such measures may be offering compensation or other redress to consumers, requiring a trader to join an accredited trade organisation, or, for example, to appoint a compliance officer. It is, in effect, as Cameron's already mentioned, an alternative to lengthy criminal investigations and subsequent prosecutions, or the use of disruption tactics. They're most commonly used when a trader has refused to voluntarily comply, despite requests from enforcers, or has agreed to comply and then subsequently broken that promise. Now, if an order is obtained from the court, or indeed a promise is made in the form of an undertaking to the court by the defendant, resulting breaches are a contempt of court that can result in a fine, removal of goods, or indeed a prison sentence. And not only can final enforcement orders be sought, but so too can interim enforcement orders, which can be sought even prior to the commencement of proceedings for a final order. So consideration should be given to such orders where it's expedient, so where it's necessary, that the conduct is prohibited or prevented immediately. So rather than waiting for the conclusion of the court process, interim steps can be taken to prevent ongoing conduct presently causing consumer detriment. So what do you need to prove, Cameron, to get one of these orders?
Broadly speaking, there are 5 criteria that need to be satisfied for a full enforcement order. First, a trader acting in the course of a business. Second, that trader engaging or having engaged in conduct which constitutes an infringement or is likely to engage in conduct that constitutes an infringement. Thirdly, the infringement has been or is likely to harm the collective interests of consumers. Fourthly, there has been appropriate consultation that has failed to stop the infringing behaviour. And finally, it is appropriate for an order to be made. There are obviously nuances to those 5, but in a 20-minute talk, we cannot cover it all. However, let's jump in now with some of the pitfalls and how to avoid them, which will, we hope, shine a light on some of the key concepts. So, pitfalls and how to avoid them. The first one is in relation to acting in the course of a business. This obviously begs the question, what is a business? Well, it includes a professional practice, any other undertaking carried on for gain or reward, and any undertaking which during the course of which goods or services are supplied otherwise than free of charge. It is intentionally broad and is obviously a key concept, but we don't anticipate this will be a major stumbling block in your applications.
Second, is the conduct infringing? There are 3 aspects to this, really. The first is that it's important to remember that these orders are only available in relation to particular listed legislation or rules of law. So you need to carefully check through which you say has been breached and whether it is available under Part A to the Enterprise Act. So check, is it a domestic infringement or is it listed in Schedule 13? If so, you're good to go. If not, you might have to think again. Secondly, future breaches. They can be the basis for an enforcement order, but they're only available in certain circumstances, i.e. only where there's a Schedule 13 infringement. And then thirdly, also note that if you obtain the order, you must ensure to draft it in a way that makes it practically enforceable, i.e. you're able to prove, if necessary, that subsequent conduct breaches the order. So, for example, you don't want to make it so general as to be meaningless, such that a contravention cannot be proved.
Next is, does it harm the collective interests of consumers? This is a fact-specific consideration. It doesn't mean you need evidence from hundreds of consumers or evidence of more than one act or omission. A small number of infringements or even a single infringement may be sufficient. The key here is to remember that the purpose of an enforcement order and this regime is to keep the general standards of trading high rather than enforce individual contracts. So in short, make sure you can evidence the impact on that general standard.
Next, have you consulted? So don't forget to consult and to consult appropriately with the trader. That means attempting to achieve the cessation of the infringing behaviour, preventing any repetition, or preventing a likely breach in relation to Schedule 13 infringements. And of course, you may need to notify the CMA before you proceed. If you don't consult appropriately, the consequences may be quite severe. Not only may you not get your enforcement order, but even if you do, you may be penalised in costs. Because the proceedings to obtain an enforcement order are civil proceedings, costs follow the event. And what I mean by that is the usual rule is the loser pays the winner's costs. However, even if you get the enforcement order, the recoverable costs may be reduced if you don't appropriately consult. You have to give the trader a chance to stop their actions, compiled with any notification and timings required, but of course don't be a slave to consultation. If the trader is simply not engaging, the appropriate time frame for consultation has passed, then move on to the next step.
So if you're going for an order, who should the defendants be? If you've got to the point of bringing proceedings, it's essential that you identify the right defendant or defendants. And there are 3 broad categories to look at here. The first is the person committing the substantive infringement. This may be a body corporate, partnership, sole trader, or someone acting on the person's behalf. The second one is if you're dealing with a corporate body, company officers, major shareholders, those telling the company what to do despite having no formal role. If they consented or connived in the infringing behaviour, they can be a defendant too. And the third is interconnected companies. If you have a group of companies, there may be a subsidiary, they may be appropriate as a defendant as well. The point here is that you must carefully consider who to go against, as it is all too easy to go against a company alone, for that company to disappear and reappear as a new legal entity free from the order. Who is responsible, and can I prove that they are responsible?
Next, evidence gathering. So often investigators feel the need to obtain voluminous evidence from consumers, with witness statements being obtained in effectively the same way as criminal proceedings. But in this case, there is no need. Often, as well as statements from consumers being read, the evidence can appropriately be provided by a single officer in a single witness statement. So survey results, cab reports, screenshots from online platforms, etc., can all be exhibited to that statement. So, having told you all about the Enterprise Act regime, as most of you are likely to be aware, and indeed as Cameron mentioned, this is all about to change when the Digital Markets, Competition and Consumer Bill gets royal assent, which is expected imminently. The 4 headline points from this, relevant to enforcement orders, are first, that Part 8 of the Enterprise Act is to be repealed and replaced. Second, CPUT, so the Consumer Protection from Unfair Trading Regulations, are to be repealed and replaced. Relevant, of course, as this was previously likely to be one of the most common infringements considered. Third, direct enforcement powers for the CMA are to be introduced, which allow for fines to be imposed without recourse to court. And then fourth, financial penalties may be imposed by the court alongside the enforcement order. The one point to note on that is there can't be double counting. So if a trader has been prosecuted, there won't be an additional financial penalty added by the court in those circumstances.
If they were convicted.
Of course. And the good news, well, the new regime for enforcement and interim enforcement orders largely mirrors the Enterprise Act regime. So much of what we've been saying will equally apply under the new regime, which can be found in Part 3, Chapter 3 of the bill. So you've still got to consider relevant infringements, appropriate consultation, and enhanced consumer measures in the previous way. The transitional provisions, though, are a little tricksy, so do be careful to check whether the old regime continues to apply or whether the conduct you are now looking at is governed by the new regime instead.
So with all of that said, let's look at pros and cons. What are they? Taking the pros first, standard of proof. The conduct need only be proved to the lower civil standard, i.e. on the balance of probabilities.
Next, the civil evidence rules apply, so you can use hearsay, and of course there's the ability to use, if necessary, a single officer to produce all of the evidence.
Next is speed. Availability of interim orders here. And the fact that civil listings can, at the moment, usually be obtained faster than criminal ones.
Next, quickfire here, the availability of enhanced consumer measures. Beyond penalties, you can really affect change in the behaviour of traders through these orders.
Then you've got the consequences of breach of an enforcement order. Breach is a contempt of court, which carries imprisonment as well as an ability to fine. So there's a further deterrent element on top of the order itself.
And of course, as we know, monetary penalties are soon to become available.
What about the cons then? Well, the first one that springs to mind is the possible lack of deterrent effect. Criminal cases always seem to have more of a deterrent effect than the possibility of civil, which are sometimes by traders seen as simply a cost of business.
Next, the financing of companies. So as Cameron mentioned, the start of one and then the winding up of that company and the start of a new one without any effect of the order.
Unfamiliarity is another con. That's both in terms of the legal community generally, but importantly the courts. Our experience is that often when you present an application for an Enterprise Act to the court, they're so unfamiliar that the procedure isn't clear to them. That often takes some explanation, but in a way you could argue that's a positive, because if we're going in as the experts and we know what we're doing, we often find the courts will follow what is said.
Next is potential cost consequences if unsuccessful. So you are likely to have to bear the costs if an unsuccessful proceedings for an enforcement order is sought.
On breach, There is a real con, which is that separate proceedings for contempt are required. Those proceedings, so the proving of the breach of the order, have to be proved to the criminal standard. That is obviously a real downside to this approach. Anyway, thanks for watching. We hope it's been useful. And if there are any questions, do get in touch. It has been something of a whistle-stop tour, but they always are on these GSLs, aren't they,
Yep.
Sabrina? So the next GSL will be on the
4th of June.
When who'll be speaking?
Jonathan Golding and Alison Lambert.
We don't know what they're speaking on, but I'm sure it'll be interesting. But for now, that's it. And we look forward to seeing you on the next one of these that we present.
Thank you.
Bye.